Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Video number 1424. On 19th January 2022, two judges bench, Honorable Justice M.R. Shah and Madam B.B. Nagaratna. They have clearly given a noteworthy judgment on a murder case. Head injury is vital to the prosecution, but there is no necessity that there should be a fracture. When head injury is caused, don't be under the wrong impression that it should cause fracture. Maybe hematoma also. This is what is observed by the Honorable Supreme Court of India in the case of State of UP versus Jai Ditt, J-A-I-D-U-D-T, in Criminal Appeal number 37 by 2022, and the appeal was allowed on 19th January 2022. So, in this case, actually, by now you could have understood that this is a case of 302 IPC. So, this is a case of 302 read with 34 IPC. Jai Datta and three others also have been included as accused in the case. Now, let us know the brief facts of the case. The deceased on the fateful day was working in the fields when the accused, followed by the other three accused, actually went there. Then first the trouble started by hurling abuses on him, ultimately beating him to death. This thing happened, and ultimately the deceased person, he was shifted to the nearby hospital in UP state, that is near Lucknow. He was taken to hospital at Lucknow, but due to the injuries, the treatment could not be successful. After 6 days of his admission, he died in the hospital. Then this A1 Jai Ditt and others, they were arrested, and of course charge sheet was filed against all of them under section 302 read with 34 IPC also. And the trial court, after hearing the prosecution evidence and also the defense evidence, the trial court convicted the accused and sentenced most of them to life imprisonment. Aggrieved by the judgment given by the trial court, they approached the High Court of UP at Lucknow, and the High Court has taken into consideration, actually has converted the murder case 302 into 326 of the IPC. Here the main twist has taken place. No doubt the PM certificate discloses that there is an injury. I will read the PM important points of the PM certificate later. But since there is no fracture, and that too the death has taken place after 6 days of the occurrence, the High Court was of the opinion that it is only a grievous injury, 326, which led to the death, but not sudden death. So therefore, the offence was treated as of 326 and 10 years imprisonment. So the sentence was modified by the High Court. Then, aggrieved by the orders of by the appeal orders or the judgment, appeal judgment of the High Court, now State of UP filed an SLP or criminal appeal before the Honorable Supreme Court of India. Now the matter has come before the Supreme Court. Right. Here, Supreme Court has clearly found fault with the High Court, stating that the High Court did not consider the nature of the injuries mentioned in the PM certificate. Right. Here, Dr. P.R. Mishra, who conducted the postmortem examination, he clearly stated that, so normally you may be knowing, for conducting the postmortem examination, first of all, they will break the head portion like this, open it, and then they will see. On opening the brain meninges, this is all brain, on opening the brain meninges, the doctor noticed that the brain was congested. Second point important, subdural hematoma over both temporal lobes. These are the temporal. This is the occipital region backside. These are the temporal regions. In this region, Subdural hematoma was found. Hematoma, not hemorrhage. Suppose if it is hemorrhage, definitely oozing of blood or coming out of blood will be there. Hematoma, it will be there inside. The blood was formed into a clot inside. Definitely death will occur. That's why in accident cases you might have seen. So many people, they will be found without any injuries, but the blood will come out from the ears. So that means hematoma was formed, not hemorrhage. So definitely they could have observed the same. Anyway, Supreme Court in its wisdom, they have clearly analyzed, they have stick to the PM certificate. So please remember, here the doctor mentioned that it is death due to asphyxia and he died due to internal injuries. And the PMC discloses that head injury is fatal. It is also real that the head injury is fatal due to which the deceased died. So therefore, since the death has taken up after a long time, and since there is no fracture to the head, these things will not go. These observations by the High Court are not correct. Therefore, the Supreme Court held that the trial court was correct in awarding the sentence to the accused, and it was held and the appeal was allowed. That means the order given by the High Court was rejected. The order means the appeal judgment of the High Court is rejected. So here you have to know two important points. Number one, there may be head injury, at the same time there may not be fracture also. Normally we will be under the impression that once there is the head injury, definitely there would be some fracture, not at all necessary. Second is the difference between hematoma and hemorrhage. You have to know what is hematoma. Hematoma is nothing but బయటికి blood రాకుండా లోపలే ఉండటం. Hemorrhage means oozing out of the blood. If hemorrhage is there, it's not fatal, but hematoma, subdural, that too subdural hematoma is there, definitely it will be fatal. So please place emphasis on these 2 points, and if you study the case, it will be easy for you to observe, to notice the difference. But normally, yes, High Court is also correct. When the death has not taken place instantaneously, that too during the time of observation in the hospital, definitely there is a lag of 6 days. So that can be taken into account. That too, it's only hematoma. Hematoma may be caused due to so many reasons. So that might have been the idea of the High Court. But whatever is, since some Supreme Court has clearly given a clarification and it has finalized the appeal, no comments on the High Court judgment. Anyway, good judgment, particularly to get the acquittal in murder cases. The lawyers should study such a type of judgment and they have to enrich your knowledge. Hope you will read the judgment and enrich your legal knowledge also. Thank you very much.